One of the most controversial decisions of the Supreme Court in recent times is the decision in the case of Senator Hope Uzodinma and Right Honorable Ihedioha. This judgment was delivered by a panel of 7 in 2020. This is the background story to the case. The case is about the Imo State Gubernatorial election that happened in 2019, wherein 70 political parties participated, fielded their various candidates for the governorship race. At the end of the election, INEC declared and returned the PDP candidate Right Honorable Ihedioha. And it was even rumored that shortly after the declaration, Senator Hope Uzodinma had done a congratulatory call to Right Honorable Ihedioha on the election win. However, shortly afterwards, the event took a different turn. Senator Hope Uzodinma headed to court challenging the outcome of the election. According to Senator Hope Uzodinma, Right Honorable Ihedioha was not elected by the majority of lawful votes cast in the election, and that his declaration and return were invalid by reason of non-compliance with the Electoral Act 2010, which was the Electoral Act of the appellants argued that the election held in 27 local governments, 305 wards, 3,523 polling units. INEC Council results in 252 polling units, collated from 2,883 polling units, and excluded results from 388 units. They claim that they won overwhelmingly in the 388 excluded polling units and had 213,695 votes, compared to the first respondents' 1,903 votes in those excluded units. They contended that with those excluded votes included, the first appellant would have 310,153 overall votes, as against the first respondent's 260,162 votes, instead of the wrong and incomplete collation that led to the first respondent being declared winner. The respondents, in responding to the case, denied any exclusion. Even INEC came to court and said the results being touted by the appellants were fictitious and false, and promised to tender the genuine result at trial. At the hearing, the appellants tendered electoral forms, ECH A, B, C, D, and E series, and called for 4 witnesses in proving their case. Some of the witnesses called by the appellants were local government agents that came and testified that they witnessed the exclusion at the collation centers. Others were the polling unit agents that bore witness to the fact that the police officers that were posted to each polling unit were given a counterpart copy of the election results for each of the excluded polling units. And the Deputy Commissioner of Police, who tendered all the polling unit results for the excluded polling units, and testified that he came to court on the instruction of the Commissioner of Police in response to the subpoena duces tecum ad testificandum that was issued by the tribunal. I bet you don't understand that term, but feel free to ask your lawyer friends. The first respondent tendered certified true copies of similar electoral result forms and called 4 witnesses in his defense, while the second respondent called just 1 witness in its own defense. The third respondent, INEC, neither called any witness nor tendered any document, despite promising that it was going to bring to court the genuine result for the excluded polling units. In essence, the respondents did not present any evidence to challenge the result sheets tendered by the appellants with respect to the affected 388 excluded polling units. This is despite admitting to the fact that electoral materials and personnel were sent to these affected polling units during the election process. The tribunal, in its judgment, held that to prove exclusion in those affected polling units, the appellants were bound to have called the polling unit agents in the 388 polling units to prove their case. It also rejected the polling unit results that were tendered by the Deputy Commissioner of Police on the basis that the police officer lacked authority to tender those documents in evidence. In essence, the tribunal dismissed the petition in its entirety. Dissatisfied by the findings and the decisions of the tribunal, the appellants appealed to the Court of Appeal. The Court of Appeal overruled the rejection of the polling unit results tendered by the police officer on the basis that he was a competent witness to testify. However, the Court of Appeal refused to attach any weight to the documents tendered by the police officer on the basis that the documents remained in the custody of the police till the election and were not certified. Further, in its decision, the Court of Appeal held that the appellant, having not joined the first and second runners-up in the election, the petition was bound to fail, and on this basis, dismissed the appeal. Dissatisfied, the appellant appealed further to the Supreme Court. At the Supreme Court, the respondent also filed a cross-appeal and brought an application to strike out the appeal on the basis of the Supreme Court's decision in Ugumba Uche Unwosu and APP, arguing further that as a result of the purported double nomination, the candidacy of the first appellant was invalid by law. The appellants, in their response to the application, argued that the issue raised by the respondent borders on the nomination of the first appellant, which can only qualify in law as a pre-election matter. And the respondents not being a part of the second appellant's political party, APC, they could not validly challenge whatever happened during pre-election time. And further, that the issue of candidacy of the second appellant had already been laid to rest in an Imo State High Court decision. The Supreme Court, in deciding the cross appeal, agreed with the appellant and held further that the issue of the candidacy and nomination of the first appellant, which was being raised for the first time by the respondent at the Supreme Court, the respondent should have sought and obtained the leave of the Supreme Court before same could be raised. It further stressed that being a pre-election matter, the Supreme Court lacks original jurisdiction to entertain it. On this basis, the cross appeal was dismissed. Now to the main appeal itself. The Supreme Court resolved the appeal on few cardinal issues, which are that since the complaints of the appellants were that some polling units were unlawfully excluded, and not that there were some irregularities at the polling unit, there was no need to call the polling unit agents in proof of their case. Since the polling unit results excluded were supported by the testimony of polling unit agents that witnessed the exclusion at the collation centers. Also, since the respondents admitted that voting occurred in these affected polling units, but only challenged the results tendered for being false, the burden shifted on them to tender the genuine results in proof of their case, which burden they failed to discharge, and that the Deputy Commissioner of Police was competent to testify and tender the polling unit results by virtue of Section 63.3 of the Electoral Act, which allows the police to have a counterpart copy of the election result, of the polling unit results to which they were posted during the election, and that the polling unit results tendered by the police was a counterpart copy of the original INEC result, which needs no certification before it can be relied upon by the court. The Supreme Court, by unanimous decision, voided the declaration and return of Right Honorable Ihedioha, the PDP candidate, then declared and returned Senator Hope Uzodinma as the validly elected governor of Imo State for the 2019 Gubernatorial election. I find very interesting and insightful the consenting judgment of Honorable Justice Unguta as very important to the justice of this case. I will read verbatim. PW5 admitted that men and relevant materials were sent to the 388 polling units for the election. The third respondent, INEC, did not claim diversion of the men and materials away from the 388 polling units. The question for the third respondent is, what happened to the result in the 388 polling units? If the results presented by the appellants were forged, who has the authentic result? Even I myself, my question to INEC again is, what happened to the 388 polling units that were excluded? Though there are divergent views about the justice of this case, and to some persons, all is not well with the decision. And this is because the Supreme Court did not consider the issue of non-joinder of the first and second runners-up. And I would say it is a notorious law that the Supreme Court has the liberty as the final court to single out the issues it considers relevant and important to decide any case. Would you rather that the Supreme Court rubber-stamped an unlawfully returned candidate in the face of the disenfranchisement of 388 polling units, or that the Supreme Court did justice when it was most desirable? I would like to have your views at the comment section. And until I come your way again, I am Oluwagbemiga Alano. Thank you.